Good day, everybody, and thank you for joining us today. My name is Sonia Clark, and I'm from First Pathway Partners, based in Johannesburg, South Africa. Our head office is in Milwaukee, United States. We are one of the top regional centers that do EB5 and E2 immigration by investment. EB5 is an immigrant visa application, and E2 is a non-immigrant visa application, whereby both you are able to actually get green cards and live in the United States. So I want to thank you all for coming to today's topic of D-Day, 1st of March 2021, the profound impact of recent South African immigration and tax law changes. And 2021 immigration law changes traps retirement funds for 3 years. So as we know, government has changed the laws around the South African Reserve Bank component of financial immigration, and the changes will come into effect from 1st of March and will effectively present South Africans who wish to immigrate and exit South Africa's tax base on a basis of residency from withdrawing the retirements from South Africa until an uninterrupted period of 3 years. There will in no doubt be a spanner in the works for many South Africans looking to leave. Today, I am very honored and very glad to introduce you to John T. Leon. He holds an LLB law degree and has 8 years of legal experience in various aspects of South African and international law, and he is admitted attorney of the High Court of South Africa. John is going to tell you a bit more about himself in a moment. John T. represents Tax Consulting SA, which is one of the largest independent tax practices in South Africa, comprising over 130 full-time professionals. And on that note, I'm going to hand you over to John T. And yes, enjoy the presentation. And you're welcome to give us questions throughout the presentation. We will get to the questions and answers, the Q&A, after John T.'s presentation. Thank you.
Great. Thanks so much, Sonia, and welcome, everyone. We've got quite a lot of content and important content to get through today, so I am going to move quite quickly. I'm not really going to go through an explanation of who I am, besides that I deal with tax law in South Africa, mainly looking at tax residency and how you break that to make sure that you're not taxable on worldwide income. Very quickly, Tax Consulting South Africa were the authors of the first of its kind textbook in South Africa with LexisNexis, called Expat Tax, South African Citizens Working Abroad and Foreigners in South Africa. And the blurb or the foreword was written by Judge Dennis Davis. You will get the slides after, so you can have a look at it. A little bit of bragging over there as we start, but I'm very proud of the book. And then I think we can get straight into it. Now, with what we're dealing with today, we need to all be on the same page with the foundation of our law. And you'll realize why as we get to more complex areas. And the first part is looking at burden of proof. And that is, as a taxpayer in South Africa, you're up against Sars. That's your opponent. And unfortunately in South Africa, the burden of proof falls onto the taxpayer, which basically means that Sars doesn't need to prove anything at all at first. It's all on you. They merely need to raise an assessment against you, which says you owe a certain amount of money. And if you disagree with them, you have to prove why they are wrong. So it's flipped, which just shows you how difficult it is to beat Sars. And I think the current statistic when going toe to toe with Sars in tax court is about 65% of the time Sars wins. So you really do have to have your wits about you when dealing with them. And this burden of proof concept is not only in our legislation, but is also confirmed by our case law. Now, how do you overcome that burden of proof? Well, we first look at how it's dealt with, and that is in the same way as any civil case is dealt with in South Africa, and that is on the balance of probabilities, which is, the scales of justice, having to overcome that 50%. And what's quite sort of alarming, that it's confirmed in our tax courts, and that is if you've got a very strong case and Sars has got a very strong case, and you're both 50%, 50%, and that is presented in front of a judge. In terms of our case law, and it says here, in the case of all things being equal, we are bound to decide in favor of the commissioner, and the commissioner is SARS. So if you've got a great case and SARS has a great case and it's equal, unfortunately, you lose. So you just need to realize how difficult it is to beat SARS and how you need to get your planning together upfront. Now, when we are looking at how do you overcome that burden of proof, knowing that you've got an uphill battle, our case law says to us that the courts are not interested in any way with your subjective intention or beliefs. They only want to look at objective evidence. And they say in this case over here from the Supreme Court of Appeal, they say in this regard, a court is not concerned with the subjective belief of the parties to the agreement, no matter how genuine this belief may be, but with whether the facts objectively viewed establish that this result was attained. So, I mean, if you must go all the way to the Supreme Court of Appeal, you must really understand that it doesn't matter how you feel, what you think. You need to be able to show, when it comes to SARS and dealing with them, that you've got all your evidence, hard evidence in place to overcome your burden of proof. And that really does come down to documentary evidence. You want to be able to show copies of old passports, showing how you've been out of the country, or show a lease agreement, or show an employment agreement. You want to actually have that hard document to be able to submit to SARS. Now, this is a very interesting case, and we're almost at the end of our sort of foundational basis for our legislation in South Africa regarding tax. And I'm not sure if everyone knows how SARS works, but they release things called interpretation notes. And what these are SARS's views on different sections of our various different tax acts, and can be very, very useful in understanding, one, how SARS views the law, and also how it would practically apply the law. And it's a bit of a guide which works very well. But we can't just rely on SARS's views. And what happened in this case, which went all the way to the Constitutional Court, which is very unusual for a tax matter to go there, is basically a taxpayer decided to very carefully follow one of these interpretation notes, but in a bit of a naughty way. And SARS then said, no, we don't like that. Even though you followed what we said, we don't like that. Fighting throughout the courts, all the way to the Constitutional Court. And the Constitutional Court finally said, in those circumstances, and this is the underlined part of the slide, in those circumstances, it is difficult to see what advantage evidence of the unilateral practice, meaning the interpretation notes that SARS issues, will have for the objective and independent interpretation by the courts of the meaning of legislation in accordance with constitutionally compliant precepts. It is best avoided. Now, that is quite damning against SARS. The Constitutional Court has said that SARS's views, they release interpretation notes on so many different pieces of legislation, and people take that as the gospel. And the Constitutional Court has said that SARS's views are best avoided. And why I'm pushing a little bit on this is because I often get clients that phone me up and say, well, I phoned SARS and they said I left the country 10 years ago, or I did one thing or the other, and I just need to do this, and then I'm fine. And I've got two issues with that. One, you've phoned a SARS call center, and you've probably spoken to someone that doesn't understand the intricacies of tax legislation, and you're now taking a view from them and taking advice from them. And two, the Constitutional Court has said, don't take SARS's view. It's the job of courts to interpret the law, not the job of SARS. SARS's one and only job is to collect as much revenue as possible. It's not there to help you reduce your liability in South Africa. So please be very careful when dealing with SARS, because what they say doesn't necessarily mean you need to follow that, and it's not necessarily correct. You need to get your own independent advice on things like this. So then, just a summary of what we've gone through quickly. Firstly, the onus of proof is on the taxpayer, and it's weighed on that balance of probabilities. And to overcome that, you need to use objective evidence only, and we want to ignore Sars's understanding of the law because they're often incorrect. And that's generally, as a practice, how we deal with it. We are made up mainly of attorneys, and we're often in tax court, where we firstly want to try and avoid tax court, and often you can't do that depending on when a client comes to you. But you want to try and set up all your evidence and your argument far before it even gets to tax court, so that you can show to SARS that actually you've got a great case and they need to stand down. And that's generally where we like to be when standing toe to toe with SARS. Now, I think this will be quite relevant for everyone, and a lot of people don't understand this. And these are tax residency tests. A lot of people think that if you renounce your citizenship of South Africa, all of a sudden you're a non-resident for tax purposes, which is incorrect. A lot of people think if you gain citizenship of another country, you will cease tax residency of South Africa, which is also incorrect. Our tax residency is determined on two tests which have very little to do with your nationality, meaning you can be someone from the UK, so a foreigner to South Africa, and still become a tax resident of the country with not ever gaining citizenship in SA. So let me quickly take you through these two tests. The first is the physical presence test, and the second is the ordinarily resident test. The physical presence test looks at how much or how many days you spend in South Africa over a 5-year period, and those are the three requirements underneath there. And you need to meet each one of those requirements fully to be considered resident and therefore tax resident. The other is the ordinary resident test, and that looks at what is your intention to be a tax resident or not to be a tax resident, and what are the objective factors that prove that intention. And we can go on quite a long time about these and get into quite a lot of detail, but I am cognizant of time, and there's quite a lot of information to get through. So please feel free to send in some questions if you've got it. But basically with these two tests, if you want to be a non-resident for tax purposes, you need to make sure you do not meet the requirements of both tests. Because if you meet the requirements of even one of the tests, you will be a tax resident. I think enough on that, and please feel free to send in questions. All right, so let's say you are a tax resident of South Africa. You probably have heard about the Expat Tax, so-called Expat Tax or Expat Exemption. It's basically the foreign employment exemption, which got amended and became effective 1 March 2020, so of last year. And as a tax resident of South Africa prior to 1 March of last year, if you met certain exemption requirements, you were able to fully exempt your foreign employment income from tax in South Africa, fully exempted. You would just need to declare it, claim the exemption, and it was exempted. Post 1 March of last year, what happened was the amended law became effective, and you can now only exempt 1.25 million rand from tax. Everything above that would be taxable in South Africa while you remain a tax resident. Now, the requirements are of this exemption that it must be foreign employment income. So you must have an employment agreement. If you're an independent contractor, the exemption does not apply to you, and there are no exemptions for you as an independent contractor, same as being a consultant, depending on how that consultancy is sort of built up. The second and third requirements are that you must be outside of South Africa for more than 183 days, and 60 of those days must be consecutive days, and this must all fall within a 12-month period where you're earning that foreign employment income. If you meet those three requirements prior to 1 March of last year, you could exempt everything. Post 1 March, 1.25 million rand. The biggest mistake I see, especially with people that meet the requirements, is they say, well, I've met the requirements, therefore I'm exempt. And that's not how it works. To be able to be exempt, you need to declare that foreign income on your tax return in South Africa. You need to claim the exemption, and you almost always will be audited, where you'll need to submit a copy of your employment agreement to show that you've met that exemption requirement, as well as a copy of your passport and a day's calendar to show that you've met the day's requirement as well. If you don't declare that income on your tax return and claim the exemption, you are still fully taxable in South Africa. And that's one of the major issues that we've seen in the past. It seems to be getting a bit better with people understanding their liability and obligations in SA. Now, obviously, due to the lockdown in South Africa last year, especially when it was hard lockdown, level 4 and level 5, people were unable to leave the country. So the government then decided to reduce in terms of the exemption requirements, the 183 days to 117 days. So those people that were stuck in South Africa during that period could claim an easier requirement. And that can come in handy for some people. I just wanted to let you know that the change, it's not a change that's remaining. It only is for the period 29 February 2020 to 28 February 2021. Now, the 3-year lockup on retirement funds in South Africa. So this law came about, at least it was promulgated on the 20th of January. So it's very, very recent, 20th of January 2021. And the background to this is, and we'll get into a bit later, that financial immigration used to be the trigger. If you financially immigrate from South Africa, they allowed you to withdraw your retirement funds, and those specific ones that are noted there, early, so before maturity date, once you had finalized your financial immigration. You could withdraw it in full and do whatever you wanted with it. The difference now is they're saying that if you've got your application for financial immigration in prior to 28 February 2021, and it's concluded before 28 February 2022, you'll still fall under the old rules, and will be able to withdraw your funds. Otherwise, will be a 3-year lock-in, 3 years or longer, because during that 3-year period from the 1st of March 2021, you're going to need to prove that you are a non-resident for tax purposes. And it's an uninterrupted period of non-resident status in South Africa. What is a little bit difficult about this is that they haven't given any regulation or indication of how they want you to prove that. My gut feel is they're going to request that you find a tax residency or a tax domicile certificate from the foreign jurisdiction to show that you're a tax resident in that foreign jurisdiction. And in terms of double tax agreements, which I'll also get into shortly, you're able to say that the taxing right falls there and that you're a tax resident that side. That's just a feeling. I don't know what it's actually going to look like post 1 March. And I mean, we've actually had some meetings with some of the big banks in South Africa to understand, do they yet know exactly what's happening? And they've come back to us to say the Reserve Bank and National Treasury hasn't given them anything, and it looks like they're putting it on the banks to try and figure it out and come to them with solutions around what needs to be done. So I do foresee we're going to be a little bit up in the air post 1 March while new regulation is properly set. All right, so now I want to get into 2 solutions, if I can call them that, of ceasing tax residency of South Africa. The one is financial immigration, and that is where under our local tax residency tests, you can cease tax residency, and this is something to prove. It's an objective factor to prove that you've ceased residency. The other is making use of a double tax agreement. So where they are different, financial immigration is a once-off process. You get its bank account status changed and you become non-resident. You're currently able to withdraw your retirement annuities, and you obtain a tax clearance certificate from Sars, which is very important, and I'll show you an example shortly. The other, and this is where you've got the intention of not returning to South Africa, by the way. You want to set up life somewhere else on a permanent basis. If your intention is that you're going to be outside of South Africa for a couple of years, and then you will be coming back to South Africa, and that is, you've made up your mind on that, we don't want to go the financial immigration route because that's not going to help you in terms of our local tests. We're going to need to look at the double tax agreement. And that's where you say, I'm a tax resident of South Africa because I have an intention of returning here, but I also meet the tax residency tests of the foreign jurisdiction, or in terms of the double tax agreement. but the taxing right falls to the foreign jurisdiction. And you'll use the double tax agreement to do that. And I'll show you an example shortly as well. So one is a permanent move from SA, and that's financial immigration, and one is a temporary move from South Africa, and that's a double tax agreement. Where they are the same, and this is very important, is that when you cease tax residency of South Africa, there's something called a CGT, a capital gains tax deemed disposal. It's basically an exit tax from South Africa where you need to pay capital gains tax as though you have disposed of an asset. You do not need to dispose of it though, and you pay capital gains tax. Once that's paid though, you can still hold that asset, and any growth further you will not be taxed on. And it's not on all assets, it's only on certain assets. In both instances, you're also able to own assets in SA, continue earning income in South Africa, send money home. It has no impact on your passports or your policies or medical aid or anything like that. So those are the differences and similarities. So I want to show you, this is an immigration tax clearance certificate for financial immigration. It has slightly changed because it's now more of an online certificate, but the details are there. And this is really worth its weight in gold, because this is your documentary evidence that you would be able to present in court if you had to, and to show that actually you've done everything in your power to cease residency. I'm going to quickly go over these, but from last year's budget speech, we saw that they firstly, well, let me actually read it out. They say, government will increase the cap on the exemption of foreign remuneration earned by South African tax residents to 1.25 million rand per year from 1 March 2020. It was going to be 1 million, but then they quickly increased to 1.25 because there were so many people financially immigrating. Some advisors have recommended immigration is recognized by the Reserve Bank as a way to break tax residency. However, this is only one factor considered by Sars. Government wants to encourage all South Africans working abroad to maintain their ties to the country. Consequently, this concept of immigration will be phased out by 1 March 2021. Okay, so a few things there. The increase, a sudden increase to 1.25 million rand because there were so many people deciding to cease tax residency. They thought, if we dangle this carrot of a bit more of an exemption, maybe people will stop ceasing residency. That's unfortunately not happened. They decided that they want to remove financial immigration as we know it and replace it with a new system, which I'll show you next. But they are removing the exchange control portion, but keeping the tax portion, which I'm not against actually. And lastly over here, where they say that they want the government wants to encourage all South Africans working abroad to maintain their ties to the country. Please read between the lines over here. They don't want you to maintain your ties to the country so they can send you a birthday card or a Christmas card or whatever. They want you to maintain as much ties to the country as possible, because the more ties you have, the easier it is for them to argue under the ordinarily resident tax residency test that you remain a tax resident of South Africa. So don't be fooled with that. Also from the budget speech last year, just quickly on it, some of the words that I've highlighted there. They want to replace the financial immigration process, but they're using words like strengthening the tax treatment with a more stringent verification process, a risk management test to include a certification of tax status. So it looks like they want to increase the difficulty of ceasing tax residency, so from the tax portion, but they want to make it simpler from an exchange control point of view. I'm all for having something formal around ceasing tax residency. Unfortunately, they haven't yet set out exactly what this is going to be. And that's a little bit what I was discussing earlier. We still need to see what's coming, but it certainly doesn't look friendly. Let's go right to the bottom of the slide there. It says, under existing international standards, South Africa participates in the automatic sharing of information between tax authorities on individuals' financial accounts and investments. These cooperative practices will remain in place to ensure that South African tax residents who have offshore income and investments pay the appropriate level of tax. Now, this is the common reporting standards. We know this. And basically, it's where tax authorities and financial institutions are sharing information. And I'm going to show you an audit which started happening at the end of last year from SARS, where this information was used. So this information is being shared. If you've got foreign assets and foreign income and you're not declaring it to SARS, SARS is finding out about it, and we're seeing some very serious audits. So quickly on this slide, it's just that we were in Parliament a few years ago fighting against the change in the exemption for South Africans working abroad. And we were again in Parliament last year, virtually though, because of COVID, to fight against the 3-year lockup rule and other various tax amendments. And unfortunately, being one of a very few tax firms, they decided that there would be no reprieve. They were going to forge ahead with this 3-year lockup of retirement funds and change the financial immigration process. And that's why we see on the 20th of January that it was then promulgated into law. I mean, there was a lot of consultation on it, but you could just tell that they were of the opinion that we're pushing this law through, whether you like it or not. You know, public comment didn't really waver them in any way whatsoever. Quickly on to the double tax agreements as well. This is Article 4 of almost any double tax agreement you will find, and it's called the tiebreaker clause. And the tiebreaker clause works in such a way that you look at the first requirement, then the second, then the third, then the fourth, and you do it in order and one by one, meaning if on the very first requirement you can already decide that the tiebreaker clause falls to one country or the other, you don't move to the next requirement. You've already finished the test. And you'll get these slides after. I'd normally go through all of this, but you'll get these slides after to read through them. But just take into consideration that you don't need to meet all of the requirements. You stop as soon as you can figure out where the taxing right will fall. You only move to the next requirement where there's a tie. And I'll give an example just on the first one. It says the individual shall be deemed to be a resident only of the state in which a permanent home is available to that individual. Now, if you've got a home in South Africa that's standing open for you to come back to at any time, you've got a permanent home in South Africa. If you've got a home in the US, for instance, and you're renting it, but you've got available access to it at all times, you've got a permanent home there as well. So a permanent home is described quite widely. You don't have to own the home. So then there would be a time you'd have to move to the next requirement. However, if you were renting a property or a home in the US and you owned a home in South Africa, but you rented that home in South Africa out full time, you don't have available access to that home. Therefore, the taxing right or the tiebreaker would fall to the US. You don't need to go to the next requirement. And that's just how you'll move through these requirements. And to even be able to use the double tax agreement, you need to first be able to prove with documentary evidence that the other jurisdiction, the foreign jurisdiction, recognizes you as a tax resident under the double tax agreement. And I've just given you two examples here. One is from the UAE and one is from the US, of basically the certificate confirming that you are recognized as a tax resident there. And then you look at the double tax, the Article 4 of the double tax agreement to decide whether the taxing right truly falls. All right. Now we're on to criminal offences, and Section 234 and Section 235 of the Tax Administration Act deals with these. And you'll see here how extremely wide a criminal offence can be, and something can actually seem like it's not all that big a deal. But in terms of our legislation, it actually is a criminal offence. And we look at the first one. It says a person who with intent to evade or to assist another person to evade tax or to obtain an undue refund under a tax act makes or causes or allows to be made any false statement or entry in a return or other documents or signs a statement, return or other documents so submitted without reasonable grounds for believing the same to be true, or makes any false statement for the purposes of obtaining any refund or exemption, is guilty of an offence and upon conviction is subject to a fine or imprisonment for a period not exceeding 5 years. Now, the reason why I want to show you this, and if we actually look at Section 234, the grounds for a crime to be committed are lesser than what we're looking at now. Section 235, it's a bit more strict. So the point is, even putting an incorrect declaration in your tax return can be considered a criminal offense. And what has now happened as part of the Tax Administration Law Amendment Bill, which has also been passed, is that they have now removed the words willfully and without just cause. And basically what this means is that previously, if you made a mistake, you were able to somewhat get away with it and it wouldn't be seen as a criminal. But now they're trying to close that gap and say, even if you make a mistake on your tax return and you've put an incorrect declaration, they can then send this to the National Prosecuting Authority to prosecute you for a crime. So basically what the amendments have done is given SARS more teeth. How they will use them, and if they'll use them, I'm not sure, but based on the audits that I've been seeing, it looks like SARS is ramping up again. I mean, SARS has even created a foreign employment team dealing with South Africans who have moved abroad and are working abroad. So specifically dealing with them because we know there are so many there. So you do need to have your ducks in a row and make sure that you are compliant and making correct declarations. So we released some of these audits a couple of weeks ago and picked up by News 24 and reports. And I just want to show you the impressions. We got 63,000 views on the one and 61,000 on the other. And the reason why I want to show you this is just how many people are impacted by these changes in legislation. And we see this abroad, on the Facebook groups with people that are very worried because they have left South Africa without knowing that they needed to do anything from a tax perspective. So this has been spread far and wide. We're often trying to get this into the media so people know, that they need to fix their affairs, because often the layman doesn't actually know these details. Now the audits. I'm going to show you two audits and I'll be quick with them. The first one over here is looking at a guy that left South Africa and then all of a sudden got an audit from SARS. And basically the audit was saying to him, give me 12 months bank statements, please, and I want to see a description of what's going on those bank statements. I also want you to submit a tax clearance application and approval for immigration. So that immigration tax clearance certificate that I showed you earlier, SARS is now requesting, you saying you left the country, well, where is your immigration tax clearance certificate? They also want you to show a copy of your residency certificate for the foreign jurisdiction. And in this case, ask them about a property that he holds in South Africa and what is the intention with the property. And then the last one of there is a bit funny and they've got a bit confused, but they say date of departure from OR Tambo International Airport on, and it's been blacked out over there. But underneath that blackout is the date and the exact time of the flight of this person leaving South Africa, which we found, quite surprising that SARS had this information, which means that they are in communication with Home Affairs, meaning, our border posts are being watched and SARS gets this information to know when you're in and out of SA. So this is just from an exiting South Africa perspective, making sure you get your affairs in order, make sure you've got your clearances to leave and your exit taxes paid, etc. The other example over here, it's quite a long one, and I think when you get the slides afterwards, please read through this. And this is an audit based on the Common Reporting Standards with that sharing of information. And here it happened. This person was, SARS got the information that this person had an offshore, I think it was a trust, and it hadn't been declared to SARS or anything. And now they ask a whole host of questions here, about this, why it hasn't been declared, is there any tax payable, wanting to know source of funds, all these types of things. The point I'm trying to make here is there is nowhere to hide your money or your assets anymore. You think because it's not in South Africa, you're in the clear. Unfortunately, it's not true. And in a case like this, it can very, very quickly turn criminal if SARS thinks there's been an evasion of tax. So please be very careful. All right. From my side, I'm basically done, and I'll take your questions. But how we generally deal with clients is we have a first call just to understand overall what your needs are. We introduce you to experts which would deal with your specific needs, and we come up with a roadmap to deal with exactly what you need, giving you sort of an outline of what needs to be done. That's it from me. Thank you, everyone.
Thank you, John T. Much appreciated. I think there's a lot of deliberation. We have had many questions from our investors, not just in South Africa, but Africa as well. So if there is anyone outside of the borders of South Africa, John T. will be able to answer your questions. I think, as we said, the clock is ticking. We need to address these issues with any of our investors, whether it be for EB5 or E2. I think in terms of what you explained, the residency under E2 may need to have that exemption, but I think let's leave that to you guys as the experts. But in terms of that, I think we need to have a follow-up webinar and maybe just dissect every single aspect of tax migration, as I think for different jurisdictions there may be variance. But global taxation is a reality, and I think we need to address that sooner or later. And I think that anybody that hasn't considered looking into the legalities, I think now is the time, for everyone to do that. And just on that note, I would like to just, in closing, while we are waiting for everyone's questions from my side, John T's going to jump right onto anybody that has questions. I'm not sure if there are any. Maybe John T can have a look for me. So First Pathway Partners, based in Milwaukee, we are an EB5 regional center, which means we have contributed over $1 billion worth of foreign investment over the last decade, meaning that if anybody wants to reside in the United States, or if you like to immigrate to the United States, there are various options. Those options can be discussed with me offline on a personal basis. You're more than welcome to reach out to me. My details are below, and I'll be more than glad to introduce you to John T and to Tax Consulting SA for them to address all your needs. So at this point in time, thank you, everybody. I would like to thank you for all your time. We'll be sending this presentation out, as mentioned, for all our LinkedIn participants that I see may not have come through. We will definitely send this out on the link for everyone to access. And thank you, John T, and we look forward to hosting you again on the next webinar.
Great. Thanks, Sonia. I can see on my side there are just a few questions which I'm happy to answer quickly, if that's okay with you.
Sure, no problem. They didn't come up on my side, but go ahead.
Sure. Okay, so the first is, hi, so how do they assess if you've been in SA for the required time? I'm assuming this is in regards to SARS and how they assess that. So there's two things. One, if SARS requests of you in an audit that you must provide information as to your location, with how long you've been in SA and somewhere else, you've got a legal obligation to present evidence on that, meaning showing passport stamps and a day's calendar. On the flip side of that, and as I was mentioning, SARS was able to see that guy in the audit, the date and time he left on his flight. It seems that SARS is also talking with Home Affairs, so that means from both perspectives they're able to find this out. But I think the main way they will get this information is by requesting this information for you, and you have no other choice but to provide it, otherwise face criminal prosecution. The next one is, my father receives his SA Liberty Life monthly payouts while in Germany. Is he still okay? He is retired and not receiving further income. Yes. So if a policy has already matured, let's say it's retirement annuity, it's already matured and it pays out monthly, there is no impact on that. Where there is an impact is, for instance, a retirement annuity where you want to withdraw it early. They're now saying, and that's based on leaving the country, you used to be able to do it immediately And now they're saying, no, we want to hold onto it for 3 years before you can do that. And I think a little bit of the worry with that is, government has all of a sudden said it's going to be 3 years. What stops them from saying another 3 years or indefinitely, or in that 3 years, increasing the tax rate for those retirement annuities when you withdraw it? So we're just a little bit unsure about what's going to happen there, and a little bit worried because government seems to be doing as they please. All right, next question. It says, to confirm, 1, if a foreigner came to work in South Africa for 3 years with the potential to become 4 years, therefore not resident in SA per physical presence test, nor ordinarily resident, then the 3-year lockup of retirement funds would not apply to them. And 2, if they became a resident through a physical presence, then the new rules re financial immigration would apply to them. So there's actually separate legislation in the Income Tax Act around a foreigner coming into South Africa, and depending on what fund they are with, upon their exit from South Africa in terms of their work permit has expired or whatever it may be, they are able to withdraw from that fund upon exit from South Africa. That has not changed. And that would still apply even if they became a tax resident. However, the likelihood is if you become a tax resident, you stayed in South Africa for long enough, they would then say, no, you need to now prove 3 years non-resident status. Yeah, so that's my answer to that. I don't know if that answered your question. All right, next question. John T. FE applications, so financial immigration applications submitted before 1 March 2021 will still be honoured. Yes, so National Treasury has confirmed that applications that are submitted prior to the 1st of March 2021 will be dealt with under the current legislation. And even though they would only be finalized after 1 March 2021, as long as they are finalized before 28th of February 2022, you would still be under the same regime in terms of withdrawing retirement funds. But to answer the question, yes, they will still be honored according to National Treasury. I don't see, there's another question. Have banks given any indication on the new process or operating as per normal for now? So I mentioned earlier that banks don't yet know, and our discussion with them was, well, 1st of March is on its way, so what will you be doing? Will you still be accepting applications? And they said to us, without further regulation being handed down to them, the status quo remains. So as far as we know, and as far as the banks know, financial immigration applications will continue as they are until a regulation has been set out by National Treasury and the Reserve Bank. I think that is the last question. Well, sorry, I see there is, one more, Sonia. Okay, so the one question is, what was the motivation for implementing the 3-year lockdown? I don't want to speculate too much over here, but I'll tell you what my feeling is. We've seen so much money leaving South Africa, or governments has at least seen that, and we've lost a bunch of millionaires, especially during COVID. I don't know if you've seen that statistic. And with people financially immigrating and ceasing residency at the rate they've been doing it in the past few years, and it really has been triggered by government changing the legislation around foreign employment income and the exemption there. If government hadn't done that and you're still able to fully exempt your foreign income, there would not have been this influx of financial immigration applications. So now they're seeing so many people cut ties with South Africa from a tax perspective that they are losing a lot of money. And my view is they're now changing it to try and hold on to some of those funds. And if we look at, and again, this is really speculation, if we look at the ANC's agenda around prescribed assets and having to invest these type of funds potentially into, for instance, an SAA or an SABC or whatever it may be, these failing institutions, my cynicism says they want to hold on to those funds so they can do something like that. I could be completely wrong. That's just my point of view. I just don't like, even more regulation around something that is already highly regulated in South Africa, especially where it's to the detriment of a South African taxpayer, and is in favor of government. That's my view on it. All right, Sonia, I think that's the questions.
Thank you very much, Jonty. I think in terms of the South African government, under the one visa program that we do have under the E2, it is a little bit short-sighted in terms of narrowing the actual regulations, because they're actually going to be making it more difficult for people to actually want to go to a first world economy earning US dollars. Because under the E2 program, we actually have to prove that applicant for that visa category wants to still continue living in their home country. They've got to prove that they still have a business running in South Africa. So I think in terms of this legislation, maybe this is a platform to maybe highlight that. We've got a lot of interested, high net worth individuals and ordinary citizens that are looking at the second option. Obviously through COVID, their businesses have suffered, and I think that they are looking for opportunities, to possibly invest in businesses, in the United States for one of the world's biggest economies still today. We have got phenomenal projects. We've just launched a new project, we've got two projects, and the one would be you investing in a business, and it's got really, really good returns. And I mean, it's outperformed during COVID. So I think this type of information is really, really key, for the investors that we've got that are looking at actually doing the E2 and not actually wishing to financially immigrate. So really important information, and I'm hoping we can engage, in the future with maybe the right people within government, the Reserve Bank, or whatever it may be, to have those discussions. And I think we've got the right platform, and considering tax consulting SA and what you guys are doing out there would be, the right organization to actually approach. So is there another question there? No, that was just still in on the last one. And to wrap it up, Jonty and Tax Consulting SA, thank you very much, and we look forward to taking any questions. You guys are welcome to email us, and we'd be very happy to help collectively.
Thank you so much, Sonia, and thank you very much, everyone, for attending. I hope it was insightful or helpful. And as you can see, Sonia's contact details are on the slide over here, so please feel free to get in contact with her.
100%. Thank you, Jonty. Have a good evening.
You too. Cheers, everyone.
Okay, bye.